was why in the federal habeas case, why you can only raise issues that you've already raised through the state cases, through the state courts, such as if you argue that your due process rights were violated at trial as a defendant. You, as the defendant argues that his due process rights were violated at trial. Before he can raise that claim in a federal habeas corpus petition to challenge his conviction and sentences, he first has to raise it through the state courts, all the state courts, the state court of appeals, the state supreme court, the state's highest court. And the question is, well, if the federal habeas case is an original petition, it's not that criminal case anymore. The federal habeas case it's not, so the original criminal case is the people of the state suing the defendant and trying to take away his freedom. They're not trying to take away his money, they're trying to take away his freedom. And that case is People versus John Smith. But when he gets to federal habeas corpus, it's John Smith versus Warden, because John Smith is now suing the warden for his freedom back, because he's saying Warden is holding me in violation of the laws and treaties of the United States. So that's the beginning of our answer, because in this federal habeas case, the prisoner is saying the warden is keeping me in violation of the Constitution. The United States Constitution was violated to put me here. So the federal court says, well, how did that happen? And the prisoner says, well, my due process rights were violated. And the federal court says, well, did you give the state courts an opportunity to fix that first? Because the federal system, you can understand this in the origins of our federal governmental system. So lots of people talk in common parlance that we are a democracy. And we are a democracy in a sense because the people, the polity, determines the representatives, determines the laws, in a sense that they elect representatives who make the laws. It's not just some outside force, lords and princes who are controlling everything. But if you understand the origins of our country, there was a lot of dispute about how much power the federal government should have, because you had 13 colonies who were breaking away from England, and they wanted to avoid this was back in the days where 13 colonies spread over from Maine to Georgia, I suppose. I can't remember the exact extent of the states, but they were far apart back then, a lot farther than they are now, because they didn't have cars, they had horses. Ships and horses were the fastest means of transportation. So they thought of their different states as almost different countries, what we would consider different countries now. And they were just joining together in a confederation to fight the British, to break free from the British. And they were afraid of another federal authority, an authority that was over all of them, like the British government was, like the king was. They didn't want that to happen again, so they put a lot of restrictions on it between the state governments and the federal governments to make sure that they wouldn't have some faraway government of people who didn't actually represent them controlling what they do and saying what they do in the laws that were passed and the rulings from the courts. So on the other hand, there's another interest, and we all of us together as a people have an interest in certain rights being respected, such as the right to due process. If the government, any government, the people of Virginia have a right to say to the people of Colorado, or the government of Colorado, like, look, you can't just take John Smith and put him in prison. You have to give him his day in court. You have to give him due process. And you have to give him equal treatment. You have to give him equal protection. You have to give him the assistance of counsel for his defense. And unless you do all that, because even though you're a separate state, we're all together here. We're going to respect each other's rights. We're going to make sure everybody is treated fairly. So you can't do that to him. And you have to give him his his due process. And now it's up to John Smith to say they didn't give me my due process. Now he's come to the federal government through the federal courts and said, federal courts, the state of Colorado did not give me my due process, and they're holding me unconstitutionally because my conviction is based on this trial where I didn't have my right to due process, or my right to effective assistance of counsel under the Sixth Amendment, or my right to a jury trial, or my right to a public trial, or my right to equal protection. And so now the federal government, the federal judge has to say, well, is that true, first of all? But before even they get to that did you bring this up to the state courts? Because we respect the state governments. Now, we're not going to let the state governments trample your federal rights, but we are going to give them the first opportunity to resolve the claim, because we're going to respect them. It's called comity. The technical term is comity. There's a famous case, comity, not comedy like laughter, comedy. And it just means respect, basically. Respect and almost a deference to the other's sovereignty. So the states are supposed to be sovereign in a sense, except that sovereignty that they've delegated to the federal government. That's the theory of our federal system. So the federal courts, to respect the state courts, they will give them the first opportunity. And if you don't present it to the state courts first, then the federal courts won't look at it. They won't even consider the claim because they say, well, you didn't give the states an opportunity. The famous case I mentioned before is Coleman versus Thompson. I think it's a 1989 case. The U.S. Supreme Court talked about this rule. It's a series of cases, actually. That's basically the culmination of those cases. And so the question arises, well, what if, so we have the exhaustion, that's the exhaustion requirement. Now it's codified in 28 U.S.C. 2254 B and C, which say that no claim can be brought in federal habeas corpus or be the basis of relief unless the claim has first been exhausted in the state courts, and the courts of the state where the petitioner is imprisoned. So the question is, well, what if the petitioner presents his claims to the state courts, but he does so in a way that doesn't follow the state rules? So the state courts have rules. They have all these court rules. That's what lawyers do, is they know the court rules, and they file the cases, they file the petitions, they file the motions in accordance with the court rules. So what if the petitioner says, well, I can't raise these claims in federal court, but I can't file a state appeal because I've already done that. So what if I just present, all the exhaustion requirement says I have to present these claims to the state court and give them an opportunity. So I'm just going to file a motion even though I know it's not procedurally proper. There's no proper procedure to raise this motion. He's just going to file it. And so he can go to the federal court and say, look, federal court, I gave them an opportunity to correct this, but they didn't correct it, so you got to let me know. Well, the federal courts have said, no, you can't do that. That's not fair. So what we have to say, well, how do we know when somebody is doing that? How do we know when somebody's trying to abuse the system? So we have to put a test to that. We have to say, well, we have to have an objective standard to say this person is abusing the system, this person's not abusing the system, and he should still be allowed to raise his claims even though he didn't present them in the proper way to the state courts. So the way that normally plays out in practice is, in Michigan as our example, the criminal defendant files his appeal to the Michigan Court of Appeals, his first appeal of right. If that's denied, he appeals to the Michigan Supreme Court. That's his appeal. And there's also something called a motion for relief from judgment, which is a motion filed with the trial judge after the first appeal is over with, and you raise claims that you would like to have, you didn't raise on your first appeal, but you should have. The state courts have certain rules. So the state courts rules are, well, you've got to raise all your claims on your first appeal. And if you don't, you've got to explain why you didn't. And the only explanation you can really get away with is my lawyer, my appeal lawyer, was constitutionally ineffective. He was so bad that the Sixth Amendment was violated because you have a right to a counsel on appeal. Say my lawyer that I had a constitutional right to didn't raise them properly, or I didn't know the evidence. Say if you discover new evidence of your innocence, new DNA evidence, new ballistics evidence, that could be your good cause. You could say, well, I didn't have this evidence before, I didn't discover it, so the only way I could raise it was procedurally improperly because there was no other way to raise it. But I presented it to the state courts, and that is a basis for the federal court to say, okay, well, we buy that argument. You couldn't raise it properly because you didn't know about it or because your lawyer was ineffective. So even though you didn't present it properly to them, you did present it to them, and they didn't grant relief. They didn't agree with your argument because usually you make the same arguments to the state court. In fact, you have to. That's another famous case. I believe it's called Edward versus Carpenter, where there was a dissent. Well, at least it stuck out in my mind. There was a dissent from that. The dissent was that, a lot of people who like puzzles might like this opinion of the court because you kind of have to prove, you have to not only exhaust your claims that you're arguing you should get a new trial on, but you also have to exhaust the claims that you're saying overcome your reasons for not properly filing these claims in state court. So it's like a Russian nesting doll. You have to keep doing all these things, and that's why lawyers make money, because the laws are so ridiculously complicated.